My lord, I would like to mention a matter, my lord. Here, my lord, there is an extreme urgency because day before yesterday, the subdivision officer has passed an order for eviction without by directing the tehsildar to evict me from this property.
Shoot property.
My lord. But here, my lord, the subdivisional officer.
Why shoot property? Is any civil proceedings is pending or
before the tehsildar civil proceeding is going on. Without jurisdiction, this subdivisional officer has passed the order. I will satisfy, my lord. Leave may be granted, my lord, I will satisfy.
When the order was passed?
My lord, on 3rd of February 2025, my lord. Day before yesterday, my lord. 3rd, my lord. And it was served upon the petitioner on 4th. Last page is the order, my lord. 37 is the operating.
Specific time which has
no mention, not mentioned, my lord. Maybe
within which period?
My lord, it is
not only a direction. The come to I hereby direct the Tahsildar such and such to evict the illegal structure constructed by such and such.
My lord.
Under
Time
section
period is not mentioned.
161.
Time period is not mentioned.
Sure.
My lord, anytime they will come and they will evict me, my lord. They will demolish my construction, my lord. Anytime. Because tomorrow is again Friday, my lord. Saturday they can come and do it, my lord. By Saturday. Anytime they will come. That's why there is an
Our notice should be given unless extreme urgency.
My lord, till tomorrow it can be interim order can be given till tomorrow. I'll serve the copy today itself. I'll serve it. It's nearby.
Oh.
It's backside of the court premises.
Granted. But you serve.
My lord, I will serve. I will serve today itself. I'll serve.
Serve, it will come tomorrow. It will appear tomorrow. If service is completed, then it.
My lord, I'll serve today.
If it is said that within such and such time it would be removed or such and
that
such.
is not mentioned, my lord. That is the whole difficulty, my lord. Anytime they will come and they will evict me, my lord.
Now, to get an interim order against the state authority, at least 48 hours notice should be given.
That's true, my lord. But the order has passed on 3rd. Without
Yes, come tomorrow. You serve in the meantime.
Leave may be granted, my lord. Till tomorrow, at least interim order may be given.
No. You serve. No time limit has been.
Tomorrow it may be.
Tomorrow it will.
Top of the list.
But if they don't come, you try to ensure their presence.
Well,
who usually appears on behalf of the
Miss Babita Das. Miss Babita Das. I'll serve extra copy to her also.
To her also.
My lord, I will.
His engagement will be regularized by the court if
My
it
lord.
is so necessary.
My lord, I will.
Yes, call the list. Yes. Yes, I have discussed the submission made on behalf of the respective parties. I do not find any infirmity in the order holding the conviction. But considering the petitioner youth, absence of criminal record, and the sentence, the 6 months is reduced to 3 months with an order to setting off the period already spent in judicial custody and police custody.
Maintain the sentence.
Sentence has been modified, reduced to 3 months. Sentence under 468 was awarded 6 months. That has been reduced to 3 months. And you have already spent for 25 days. The rest day you have to stay.
Trial court's judgment for a limited period. Otherwise, now I am now working as a government servant in some other department and I am in service.
I have given 3 weeks time.
Sir, from what I pray, because I'm I've been given job in some other department. I'm working. I'm now government servant. If the order is carried, so I have to serve my rest of the sentence with penalty director. The trial court's judgment needs to be stable. Some that I can. And I'm a private person. I could have asked my client to visit Pratrapur jail once. But since he's working since he's a government servant as of now, he got the job in some other.
In that circumstances, I can record things that later, after passing the order, you have made a prayer for stay of operation of this order. That is order passed by this court. We are considered and refused.
Trial courts. I'm not asking for this. Trial courts.
Cannot.
I have given within time 3 weeks. If you want to ascend in this order, go to the Supreme Court within that period. বন্ধ করে দিতে
My Lord Rakesh Kumar sir, appearing for the respondent, I am praying for short Passover 226.
That matter. এটা তো চিফ সেক্রেটারি intimator up to
It's for till tomorrow, till 7. It's operating till tomorrow.
so not today.
Short Passover. These are two places before the closing of one.
Okay, pass over let him.
Become 7 WPA 11 of 2025.
Your Lordship, my senior is appearing for the official respondent, Your Lordship. I pray for Passover. My Lord, my senior is appearing for the petitioner. I'm praying for a short Passover.
Pass over. Okay, pass over.
Item 8 WPA 20 of 2024.
My Lord Rakesh Kumar sir, appearing for the petitioner. I'm praying for short Passover.
Pass over. Okay, yes.
Item 9 WPA 6 of 4 of 2024. WPA 6 of 2024.
For the state,
Uh,
between two private parties, and for the state.
9 and 10.
My lord, I'm appearing for the petitioner in serial 9 and 10. My lordship, this is a pattered matter. I had already argued on the last date.
Here one Anjir Ali was, where is the Anjir Ali? Where is Mr. Anjir? Do you know, Mr. Anjir Ali on that date, he
Lordship.
we have engaged by the
Lordship.
Legal Aid Services Authority to defend the respondent number 1.
Lordship.
But I am to recall this order because of the fact that office says that in computer system adopted by our court, there is a procedure that the one civil matter can be, civil petition can be converted to a criminal division in that way. So actually, a procedure is the civil matter is to be disposed of with a liberty to the petitioner to file criminal division afresh. Actually, you have not, at that filing department has not checked it.
My lord, but as per my lord's instructions on the last date, the department has converted it to CRR from WPA. And
No, I am told by the department concerned that there is no system and computer will not recognize.
okay.
Once
My lord, but this
on automatic, it would be uploaded, the order, everything is systematic. But system will not permit in this way. Actually, at the time of when 227, read with section 528, then it should have been registered as CRR. So where is Mr. Angelali?
my lord, there are
Ah,
two advocates are appointed. One is appointed in serial 9 and one is appointed in serial 10. Two different advocates are appointed, but both are connected matters, same facts. My lord, repeatedly they are not appearing for defending the accused persons, and lordship may close the matter today because last date also last chance was given to them, and they have been appointed before almost 2 or 3 months, lordship.
you know whether Mr. Angelali is available in court today?
Your Honor,
Huh?
it's very much available.
Very much available. So ask him to.
Your
Ah,
Honor,
I'm passing it
short
over.
passage.
Okay, I'm passing it over.
Lordship, what time will it be called out?
Okay, let him come. Give an information that court want his presence.
Your lordship has been kind enough to give him a lot of. He has not been appearing repeatedly despite reminding him again and again. Lordship, what time will the Passover matter be called out?
Okay, it would be.
Kindly try to the earliest.
Oh, he has come. Okay.
Very well.
Yes, Mr. Ali.
Your Lordship, I was appointed to Messilasi, and the whereabout of the my client, I was not the lawyer in the trial court, and I find that the order passed by the trial court rejecting the petition of the petitioner, it's bad in law. The reason is that
Yes.
is bad in law
Oh.
and it has to be set aside.
That is my prayer in this petition.
It is
No, it is the proper assistance given to the court. Yes, now you say.
Lordship, I finds that the lower court has passed the order that and declared the accused as a proclaimed offender. In page number
Basically, the learned, yes.
page number 45, Lordship.
Page number
Kindly
45.
come page number 45.
Yes.
In the last para, considering the submission of the learned counsel for declaring the accused as a proclaimed offender. And
Yes.
yes, the accused is hereby declared as proclaimed offender.
Hmm.
Thereafter, another petition was filed by the petitioner that to allow under section 82, that too allowed, and the paper publication is done. when thereafter, when they pray for direction to be given to the SHO for lodging of this section 174 IPC, on that order, she has rejected. Kindly come to the page number 49, Lordship. 49, para
Yes.
1, 2, 3, 4,
Page
5.
49.
Fifth para, it further appears for the case record that the void order number 52 dated 14/7/2022, the SHOPS Aberdeen was directed to submit report regarding the publication and execution of ER of WP and warrant of arrest WA against the accused person, but no such report has yet been received. Then in the down, PS Aberdeen to lodge the as the accused was not declared as proclaimed offender. Now she is again saying that the accused was not declared proclaimed offender. In the earlier the page number 40.
So the learned magistrate was not factually correct.
Yes.
Okay.
Yes.
Then they challenge that order before the session judge.
Hmm.
The session judge has not called, I think, the lower court record
Hmm.
and not gone through these two findings.
Yes.
He might gone through the last order of the trial court
Hmm.
that the warrant is still pending and the the accused is not been declared as a proclaimed offender. That's why the session judge has rejected the
Hmm.
petition of the complainant.
Session judge has said that WP has been issued. It is waiting for execution, page 86. Hence, I think that complainant should wait for execution report as because the case has been filed for realization of money of the check in question. But it is the contention of the learned advocate defending the petitioner is that such complaint and the offense under section 174 or 229 is independent of any procedure taken under 82. Yes.
The 82
relied upon
procedure
the
for 82.
judgment also. Yeah. What is the judgment he relied upon? Most probably in another record. He relied upon judgment also.
Daljit Singh versus State of Haryana. The minute the proclamation is issued and he fails to appear, the offense stands committed.
Will also kindly come to the page number 34. The
Page
number
number
34.
34, yes. 34. Yes.
The last para, it is found that no affidavit was shown by the complainant as required under section 83 clause 1 A and B of CRPC. And subsequently in page number 35.
Hmm.
Now regarding the prayer of circulation of order of issuance of proclamation warrant in the local delegate, she has allowed under section 42 clause 2 of CRPC, Lordship.
Hmm.
The complainant, as per the lodging of the FIR under section 174, all the formalities that she has completed, Lordship.
Well, all the formalities are completed.
For initiating the section 174 IPC, section 82 has to be allowed first. Section 82 is allowed and the publication is already done.
I'm grateful for my learned friend for supporting my case, Lordship.
But the thing is that, Lordship, accused has already left India.
India,
He is not now in India. He is
how you have come to know?
I came from my learned friend, Mr. Pardesia. He has
Pardesia, who is
already
Pardesia?
received the court.
Here? Oh, junior to you.
He has left to Guinea, no?
Guinea, Republic of Guinea, Africa.
Republic of Guinea.
Oh, so you all know the aware of this fact.
I came from this record only, whatever supplied to me.
From the, what is this?
It is already mentioned that the accused is already left to Guinea country, and
Page 31.
Now, whether
page
it
30, page 31,
31,
page 31.
it is on record, it's come on record.
Yes, Lord.
Yes, Lordship. Yes, Lordship.
Oh,
So purpose of this section, adding of the section 174, I think not be used, Your Lordship, because if this section will be added, then also the accused is not in India.
okay. So hard. I'm trying my level best so I can give order on Monday.
Lordship, may I just make two submissions to rejoin the submissions of my learned friend?
Yes.
Yes, what my learned friend is contending that the accused has already absconded and registering an FIR under section 174A will not serve any purpose. My lord, there is no force in this submission. First, because the offense is already committed, this crime cannot go unpunished. Secondly, that is my precise case that because he has absconded, he has no regard for the judiciary of India. He should be tried for a separate offense. This is a separate offense and he should be tried for it. And this will certainly help me in procuring his presence before this honorable court because, my lord, my conviction warrant is still pending execution. The minute he comes back, he must be tried for the various offenses that he has committed before this honorable court and before the trial court. My lord, the police will definitely come to my assistance if the accused persons are traced by way of further investigation by registering an FIR under section 174A. My lord, until and unless that is not done, I don't know, infinite we will be in the hope that someday accused will come back and only then FIR must be registered. That cannot be the case because once offense is committed, the crime has to be registered, and that is exactly why the criminal amendment was brought in 2005 and section 174A was introduced to deal with such accused persons who have no regard for the court, lordship. Therefore, my humble prayer that directions may be given to the SHO Aberdeen to register FIR under section 174A and section 229A, lordship. I am grateful.
Okay.
Probably.
We'll give him that too. Okay.
I'm grateful, lordship.
Next.
Item 11, WPC 37,104. I have to consider. Paying some time for filing my reply now.
Yes, Lord. This is the matter you must remember.
Oh, the father, one. You are
I have to consider.
The record
petitioner, father.
is my brother and he wants deletion of my name from the revenue records. The record was called for. Okay. Or the hearing was done.
You should have actually filed today reply.
No, some time may be given.
Please seeking time and.
You are avoiding.
Correct.
Oh, what can be done?
Yeah.
Yeah. Acha, what's your name?
Sudipta Haldani.
Acha, Mr. Sudipto Haldar. Learned advocate appearing for the petitioner, prays for extension of time to file affidavit in reply. Stop. Where is considered and allowed. Let such affidavit in reply be filed within
Next circuit.
Within a week from date? Huh? So within a week from date? Let the matter appear before the next circuit bench. Let the matter appear for further consideration before the next circuit bench, comma, subject to his convenience. এইটা আপনি নির্ভুল টাইপ করতে আপনাকে যদি এই স্পিডে কেউ বলে সে I shall write it long. Yes.
I can do a CRR2 of 125.
I am for the state lordship. It's a discharge under POXO Act rejected by the trial court.
What has rejected?
227 for discharge.
Oh, discharge.
Discharge.
So tomorrow? Many matter has been passed over. Okay, passed over.
I can cutting CO 61 of 124.
Yeah.
Case because there the records found to be missing. The
Oh.
entire records were missing. And thereafter. And thereafter I supplied the certified copy of the documents to the learned court below. So that the learned trial court can proceed further with the case for appointment of commissioner and commissioner's report and that final decree. But since last 2 years, the matter is pending, calling for records from the recording.
You are appealing for?
For respondent, your lordship, I'm praying for Passover, your lordship.
I am giving a direction,
Your lordship,
let the record be reconstructed as per the prescription of civil rules and orders.
let it be Passover, your lordship, is on like next item is of my senior, code number 1. I will
Every
take
matter
inspection,
passed over.
I will take inspection, I will make submission.
Okay, pass over.
So 14 CO 5 of 124. I can 14 CO 5 of 124.
I pay for the respondents.
Who is for the petitioner? Petitioner is Ms. Das. All matter pass over, all are busy in that court at a time. How can it be? Yeah? At a time, all councils are busy in court number 1. Okay, pass over.
Item 15 CO 6 of 125.
I am hearing from the petitioner, my lord.
Hmm.
Here, my lord, a suit was filed wherein the interpretation of a registered lease deed was the subject matter. Now, my lord, there evidence was led by both the parties and the case was at the verge of culmination into a judgment.
Hmm.
Now, my lord, at that stage, an application under Order 6, Rule 17 was taken. And that was allowed. That is challenged in this civil revision.
Have you served upon?
My lord, since it's a civil revision, my lord, unless and until my lord admits it, I.
Oh. Willing to you. Now, why at the verge of the after completion of evidence,
Yes.
before argument, the amendment application has been entertained.
Entertain.
Now,
They filed an application.
Whether court cannot do it.
No, my lord, under Order 6, Rule 17, if my lord sees the proviso clause.
Provides so that means, yes.
Yes.
They are
Proviso
prevented.
says It cannot be. Normally, it cannot be. If my lord sees, I will read it. My lord, please. I will read. My lord, may kindly come to Order 6, Rule 17. Amendment of pleadings. The court may at any stage of the proceedings allow either party to alter or amend his pleadings
in any manner and on such terms as it may just, and all such amendments shall be made as may be necessary for the purpose of determining the real questions in controversy between the parties, provided that no application for amendment shall be allowed after the trial has commenced, unless the court comes to the conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of trial. So, my lord, the language is shall. It is mandatory that it shall not be, unless the court come to a conclusion. Now, my lord, by these means of this application, they intend to bring certain facts, my lord, because at the inception itself, I have submitted, my lord, the issue in the civil suit was pertaining to interpretation of a registered lease deed. So therefore, on merit, I will argue, my lord, once other side comes. Therefore, at this junction, it could not have been. They adduced two witnesses. Defendant was examined. One more witness was examined. And thereafter, my lord, at the verge of last chance was given for them to adduce evidence. They taken out this application, and in a loath manner, I will say, my lord,
Last chance was given for
evidence.
evidence. Oh.
And there was an order of this court whereby directed to finish the trial within a time frame that lapsed long back.
Oh. So this instant revisional application has been papered invoking Article 227 of the Constitution of India to challenge the justifiability of the order dated dated 10th January 2025, passed on an application taken out by the defendant under Order 6 Rule 17, seeking amendment of the, so defendant amendment of the written statement, so amendment of the written statement. Stop. Mr. Kumar, learned advocate representing the plaintiff petitioner, submitted that such amendment falls within the mischief of the proviso of Order 6 Rule 17, and the defendant could not made out any case that in spite of due diligence, they failed to bring such facts before commencement of the trial. He submits that the defendant, what they want to say, bring
Incorporate certain facts.
Which may entail that change of
Absolutely, my lord, because
he submits that the defendant want to introduce certain amendment in the pleadings, which may result in the change and nature of the change and character of the suit. ঠিক আছে? In view of this fact, the order under assail in this division is flawed. Stop. Having heard the learned advocate and upon perusal of the record, because I am of the view that a prima facie a good arguable case has been made out in this petition. Accordingly, the revision is admitted.
My lord, let there be a stay because on 20th, the date is there, my lord, for filing WS. Amended WS.
ঠিক আছে, there shall be stay of all further proceedings of other suit number 138 of 2015 till the end of March 2025 or until further order, whichever is earlier. Stop. Petitioner is directed to let this matter appear for further consideration in the next circuit bench, comma, subject to his convenience. The petitioner is directed to serve copy of this application upon the opposite party's hearing and file a file affidavit of service on the returnable date. ঠিক আছে? হ্যাঁ। Next,
Item 15, PRA entry of contribution.
criminal appeal.
I am for the state, Lord. The accused person was connected. Was the acquitted, the victim has filed this appeal against acquitted.
I'm paying for next circuit, Your Lordship.
You are appearing in this matter?
Yes, I am.
Oh. You appear in criminal matter also?
One or two, Your Lordship, it's complaint cases here.
Okay. So next circuit.
Yeah.
Against acquittal? What can be done? Acha, as paid for on behalf of the appellant, comma, let the matter appear before the next circuit bench, comma, subject to his convenience. Yes.
Item 17, essay 1 of 2025.
Sorry, I sought for adjournment only on the ground of the 17th. Because we have only 2 days. Practically, working days are only 2. And the second meeting has already started. So it will take time. And if 16
So
starts.
next circuit.
No, I want to do.
Oh,
I
yes,
want to
yes.
do.
Who is your other side?
For that reason, I sought adjournment in 16.
Oh,
That's what I want to do.
My senior is praying for next circuit.
No, Your Lordship, already the matter was started.
who is your senior?
Mr. Jaipal, he already started the matter.
Joypali was here now. As and when it has been called, he has gone outside.
Argument started yesterday. I prepared.
Yes, yes. Mr. Joypal started the arguing the case.
This particular brief and made myself ready in item number 16.
I will take instructions and come. Pass over, madam. That is matter.
Okay, pass over, short pass
Short
over.
pass.
You take instruction whether you will.
Item 19, essay 8 of 2024.
19.
Your Lordship, my paper book is ready.
Have you served upon the opposite party?
Already served, Your Lordship. Mr. Rakesh Palgovind appears. I've already served.
What can be done?
It's a difficulty, what should I say? Very short point is involved, whether sale agreement is required to be registered or not. That is the issue here also.
Even I have not argued substantially yesterday. Even I have not argued substantially yesterday. This has to be taken into the next.
No, my objection is, Your Lordship, the reason is that if he had told me yesterday, I would have prepared for other second appeal. There are 3-4 appeals of mine.
Would it be a ground to raise an objection? Madam has
Your
been,
Lordship,
mind has
because
been refreshed.
We are wasting our time, Your Lordship. I have
It
taken
is in
action
between
at
us.
16 for this reason.
It is in between us. Within family, it is not here. If you say this, please, I shall move it. I may take the brief also, can read. They are- No, you are learned friend.
Refresh, that's the thing. Main break.
It is up to you.
I can start. Don't know.
When we have started, we can complete.
Probably if it is not, I shall take it to Calcutta and from video conferencing, I shall pass the order. If you complete.
My lord.
My
lord's objection, my sister's objection may be sustained.
Objection.
Sustained.
Yes.
Item 17.
I'll just show the.
Yes. SA 1 of 2025 and SA 2. You are appellant of?
Appellant defendant. Appellant defendant.
No, here two appeal.
Two appeals.
You are appellant of?
In both the appeal.
Oh, both the appeal you are
Yes, yes.
appellant. Achha. Okay. Okay. Yes.
Yesterday I was just enlightening the fact, not that in view of regulation 204 being prescribed.
Yes. Yes.
One cannot maintain a suit. I could have understand a lot that in a suit, declaration of right title has been claimed in a case where recovery of past possession has been sought. In such a case, this is not within the domain of a revenue authority to decide. Then that bar of 204 will not apply. But if it is suit for recovery of past possession simplicity, without claiming any declaration as right title, then the only course left is to approach the revenue authorities. If within 2 years it is not approached, the suit is not a remedy. My point of argument is suit can't be a remedy. No, it's something, it's based on a well-known maxim, generally especially was non-derogatory. If a special statutes provide that a remedy has to be exhausted in a particular manner, it can't be done in a general way. No, let's go with the regulation 204 once. Fine.
Yes.
Under chapter Roman 17.
Yes. Yes.
No suit or other proceeding shall, unless otherwise expressly provided in this regulation, lie or be instituted in any civil court with respect of any matter arising under or provided for by this regulation. What my understanding so far as 204 is concerned, if this regulation provides any remedy, then one has to exhaust that remedy under the regulation. Suit is not the forum. One cannot approach a civil court. Now, this is a case where the plaintiff said before the court below that I have occupied a portion of his recorded land. If that be the case, then he should have approached to the concerned Tahsildar in terms of regulation 161 at page 33.
One 161. Yes.
161. If after commencement of this regulation, any tenant is dispossessed, it's wrongly typed as disposed of any land held by him otherwise than by process of law, he may within 2 years from the date of such dispossession apply to Tahsildar for his reinstatement in such land. On receipt of an application as subsection 1, the Tahsildar shall, after making an inquiry into the respective claims of the parties, pass order on the application, and he orders the restoration of possession of tenant put him in possession of land. The Tahsildar may at any stage of inquiry under subsection 2 pass an interim order for delivery of possession of land to the applicant if he finds that the applicant was dispossessed by the opposite party within 6 months prior to the date of submission of application under subsection 1, and if the possession is not delivered to the applicant, the Tahsildar shall cause the opposite party to be ejected. When an interim order has been passed under subsection 3, the opposite party may be required by the Tahsildar to execute a bond for such sum as he may be deemed fit for abstaining from taking possession of land until the final order is passed by him. If the person executing the bond under subsection 4 is found to have been entered into or taken possession of land in contravention of bond, the Tahsildar may forfeit the bond in a whole or in part and may recover such amount from such person as an arrear of land revenue. If the order passed under subsection 1 is in favor of applicant, the Tahsildar shall also forward reasonable compensation to be paid to the applicant by the opposite party, provided that the amount of compensation shall not exceed 10 times of land revenue payable in respect of land for each year's occupation. Any compensation awarded under subsection shall be recoverable as an arrear or land revenue. Now to see 161(1), It-
161(1).
One.
Yes.
It's given.
That has given a right to approach the.
Court cannot see if it has to be made within 2 years. But does not preclude a person to approach even after 2 years. My point of argument, it's not a mandatory. The 2 years, which is preceded with this conjunct may, makes this provision a directory in nature insofar as approaching to the Tahsildar within 2 years. But civil court cannot be approached because the remedy is already provided here. The trial court, while dismissing the suit, one may ask why 2 appeals. Some issues have been decided in favor of plaintiff. The issues as regards my alleged unauthorized occupation of the suit land has been decided against plaintiff. But on the point of jurisdiction, the court held suit is not plaintiff. So my
The trial court.
but in the first
The appellate court, reverse.
reverse,
Or
as far as
the-
that issue is concerned, to reverse. Take that suit is well maintained. Considering this provision in a different premises, I'll show that. But kindly comes to the trial court's judgment. I'll take one out, I'll not bother my lord to read the entire judgment, only those issues where this issue of 204 has been dwelt upon.
Hmm. No, here we are question, a substantial question of law here. We are involved, concerned.
Yes.
So 204 says that any matter, that means the matter arising under and provided for by this regulation have been or has been excluded from the domain of the civil code.
Absolutely.
Let us point out.
Madam,
Uh,
madam.
Now, the question is whether the dispute involved in the suit or in this matter falls within that any matter.
Yes. But any matter.
But prima facie it appearance that 2 years have been exceeded, have been expired.
Madam.
Before 2 years, the person concerned who felt aggrieved, he approached civil court.
But if that be the case, then claim must contain a prayer as regard declaration of right title. Simply said, recovery of caste person cannot be claimed. That is my point of argument. I am saying, Lordship, let's go with that situation method. I have occupied the land of the plaintiff. Meaning thereby I am in possession of the land of the plaintiff, be it 1 square meter, be it 200 square meter. Because by passing.
I am coming to that. Basically, section 9 has given a power to the civil court to proceed.
Absolutely. Civil nature of dispute.
If the legislature want to prevent the civil court to proceed, then there must be explicit bar.
Bar. Absolute. Express bar.
Otherwise,
Hold on.
presumption would be court has power to proceed.
It's not powerless. Absolute. Absolutely.
Court has power to
Hold
order.
on.
If you want, being a legislature, if you want to prevent the court from proceed, there must be a specific bar.
Madam.
Specific bar means you cannot make anyone without remedy.
Madam.
So you have to prescribe a remedy.
Madam.
So that in our mainland there is a Land Reforms Act or such and such. Regulation.
Madam.
But whether if any person acquired the land and 2 years expire, whether he has got any remedy under this regulation.
Not solely I said, Lordship, this conjunct of may has a significant role under regulation 161. It says one has to approach Tahsildar within 2 years, may. That does not preclude one who can approach even after 2 years. I could have understand that there is a usage of what shall. Shall makes a mandate, the provision mandate. I could have understand it shall use within 2 years. If it is not done, civil code. But this says one can approach Tahsildar within 2 years. My point of argument is, even if the plaintiff has not approached, let's go with this situation that 2 years have lapsed. Even in such a case, suit is not a remedy. He still can go to the Tahsildar. In the present case, he has already approached the Tahsildar. I'll show the pleadings.
After 2 years.
Their plain says, I'll show that not. I'll show that there.
So what Tahsildar did,
Matter is pending.
since the civil suit is pending.
Yes.
Okay.
No, doctrine of election monotonous. I can seek for one remedy. I have elected to go one forum. The plaintiff have already approached the Tahsildar. Invoke this 161 regulation. During the pendency, till the Tahsildar gives a logical conclusion to the proceeding, suit was filed.
Okay, but first take us to the pair made in the plane.
Absolutely. One of kindly stands to page.
Page
of the paper.
3, huh?
A decree against the defendant for eviction from an area of 74 square meter out of total area of 3132 square feet is in survey number 47 at Jangligarh under Port Blair Tahsil.
So admittedly, no prayer for declaration of title has been made.
My lord.
Admittedly.
Admittedly.
Now proceed.
My lord. And lordship, prayer B may kindly receive decree against the defendant for recovery of khas possession of the suit plan. Well, I'll just show one more thing, just 1 second.
Yeah.
My lord. Paragraph 8 of the plain.
Paragraph 8.
8.
Yes.
This one. Or paragraph 8 has to be read with paragraph 13. First of all, place paragraph 13. The
Yes.
cause of action for filing the suit arose on 30/3/1999 when the plaintiff first come to know that the defendant has illegally occupied upon 74 square meter of land out of survey number 47, an area of 3132 square feet situated at Jangligarh. And the plaintiff asserts that 99 is the year when he has come to know about unauthorized occupation. And then the approach was made, paragraph 8 of the plaintiff. Paragraph 8 of the plaintiff. 99 only. Thereafter, the plaintiff herein filed petition before the Tahsildar and a revenue case was initiated being RC number 962 of 99 and the Tahsildar Port Blair has issued show cause notice upon the defendant herein to show cause as to why the unauthorized occupation from the said land should not be vacated. So I go with the plain case, Lord. Plaintiff says 99 he has come to know about my unauthorization. And on during 99 itself, Tahsildar was approached. Tahsildar set this proceeding in motion.
Now, where from I shall get that in 99 itself he approached the Tahsildar. No time limit has been stated.
99. Revenue case number. No, can you see the number of revenue case? It's 962/99. Same year. So only yesterday I argued, my lordship, the plaintiff approached the Tahsildar seeking my eviction. He claimed that I am an authorized occupant. Please remove defendant. Tahsildar, based on his complaint, which was made during the year 1999, set this proceeding in motion. What is this proceeding? 161 proceeding. I have been given a show cause notice why I will not be thrown from the suit line. And then, my lord, paragraph 9 make allegation that the defendant herein did not take any steps and thereafter plaintiff again issued applied for demarcation before the Tahsildar Port Blair. The demarcation of the said land.
Yes.
The hearing number so and so was conducted in presence of area patwari, revenue inspector, and site plot holders, and after demarcation, it was found that an area of 74 square meter of land has been illegally occupied by Sri Peter Balla out of survey number 47. That thereafter the plaintiff requested the defendant many times to vacate the illegally occupied, but the defendant did not vacate the said land. So if plaintiff says in the year 2002 when the suit was filed that Peter Balla is there, I have approached the Tahsildar, Tahsildar set the proceeding in motion, demarcation was held, then why the Tahsildar was not compelled to take appropriate action in terms of that proceeding? Why the suit was lodged in the year 2002? Nowhere plaintiff says that any logical conclusion was given by the Tahsildar insofar as that proceeding is concerned. Why suit? That's my point of argument, Lord. It goes to the very root and the court below, trial court, not to see those issues. The trial court have dealt with this issue, saying that suit is a bar. To just gloss up the entire issue, not kindly see the conduct of the parties. The civil suit entirely based on preponderance of probabilities, not most. Conduct plays some role, to some extent role. In one hand, plaintiff chosen to invoke 161 till the Tahsildar says something finally, suits are being filed during the 2002.
Yes.
Now I'll just show how the trial court have dealt with it. Now you see page 52 of the paper book. Look, page 59 may kindly listen, not page 59, running page 59, internal page 8 of the judgment of the court below.
Yes.
Issue number 167. These issues were decided against the plaintiff.
Yes.
May I please?
Yes.
Learned advocate for the defendant argued that in view of the provision of section 98, 161 and 204 of the Andaman and Nicobar Islands Land Revenue and Land Reforms Regulation 1966, this court has no jurisdiction to try the suit, and the suit is not maintainable in its present form and in law. He argued that the plaintiff filed petition before the Tahsildar court Tehsil for eviction of the defendant and a revenue case being RC number 962 of 99 was started, but the plaintiff has not stated anything in his evidence regarding the matter as to whether the said revenue case has been finally disposed of or not. He also argued that only the revenue court has jurisdiction to try the matter in view of the provisions of the said regulation. In reply, a lawyer for the plaintiff argued that the plaintiff filed the petition before the circular court for demarcation of land and not for reinstatement, and that as a records of revenue case was misplaced, lost, the witness could not produce a record before the court. The plaintiff has averred in the plain that RC number 962 of 99, the Tahsildar court has issued notice upon defendant directing him to file show cause as to why his unauthorized occupation from the suit land should not be vacated. So it is clear that the said revenue case was started regarding the matter of eviction of the defendant from the suit property. Section 204 of the Andaman and Nicobar Islands Land Revenue and Land Reforms Regulation 1966 provides that no suit or other proceeding shall, unless otherwise expressly provided in the said regulation, lie or be instituted in any civil court with respect to any matter arising under or and provided for by this regulation. As per section 161 of the said regulation, if after commencement of the regulation any tenant is disposed of any land held by him otherwise than by process of law, he may within 2 years from date of such disposition apply to the Tahsildar for his reinstatement in such land. The Tahsildar shall, after making an inquiry into respective claims of the parties, pass order on the application, and when he orders for the restoration of possession to the tenant, put him in possession. From the above mentioned provision of Andaman and Nicobar Islands Land Revenue and Land Reform Regulation 1966, it is clear that the civil court has no jurisdiction to try the suit. Therefore, I hold that the suit is not maintainable in the present form and in law, and I further hold that as the suit is not maintainable, plaintiff is not entitled to get the degree or any other relief as paid for. So this pleadings, this averment in the pleading was taken care of by the court below, trial court. That it's a plaintiff who has averred in the plaint about the alleged disposition 99, the approach of the Tahsildar during 99. But as it was rightly following from my lord that in terms of section 9 of the CPC, civil court has a jurisdiction. But if there is an apparent bar, then even civil cannot get into those issues, Lord. Particularly when in the present case, suit is a bar. Not as only I'm saying at the cost of repetition, had there been a prayer for declaration of right title of the plaintiff in respect of the suit scheduled land, if the plaintiff claims to be in possession of defendant, I can understand. This issue cannot be adjudicated by any of the revenue officers under the local regulation. The 204 will not attract there. But in the prayer, there is no declaration claim as regards right title interest. One has to claim, not in the nature of the present dispute, one has to claim this relief. It's a primary relief. This has to be a primary relief. The recovery of past possession is always a consummation relief in terms of section 34 of the Specific Act.
Yes.
So this is my first point. Look, the trial court while deciding other issues, have considered the report of local commissioner to come to a conclusion.
Whether you are in encroach or not.
Yes,
The trial court has concluded that you have encroached, but since they have approached that and there is a bar under section 204,
yes.
the suit is not maintained. Yes. There is a judgment, whether the annotation they have ruled that despite the bar, there are certain things that a violation of principle of natural justice or anything like a certain condition one can approach. That despite existence of alternative remedy, one can
That's
approach.
one judgment, Manoj.
Even section 9. Section 9. Yes, you proceed.
For that, the case has to be made up, not even for that, there must be a pleading in the pleading. There is no case being made up before the trial court by the plaintiff. Now, the questions were formulated by the division bench. I will take note of the report of the commissioner. There has been exhibited as 3G, local investigation report, and the evidence of PW2. Because issue number 2, 4, and 5 gone against the defendant. 2, 4, and 5. Now, let me take note of exhibit 3G.
Now that issue is issue number
Maintainability.
1667. You just use what? 167.
1, 6, and 7. Issue number 1, 6, and 7.
Exhibit 3G, that local inspection investigation report.
My lord. Again, I will draw a lot to that.
Yes. Exhibit 3G, page.
Just one. Say report dated 8 November 2007, my lord would find at page 29. Page 29.
Yes.
The land bearing survey number 47, area 3132 square feet, 291 square meters, recorded in the name of plaintiff Jageshwar Lal, and survey number 49, provisional survey number 1130 and 1129, area 345 square meter, recorded in the name of defendant Peter Balla, have been demarcated on 27/10/2007 in compliance of the order dated 13 September 2006 of the Honorable Civil Judge Senior Division South Andaman and Port Blair in other suit number 14 of 2002. Jageshwar Lal plaintiff versus Peter Balla defendant. On demarcation of land bearing survey number 47, area 3132 square feet, 291 square meter, recorded in the name of plaintiff Sri Jageshwar Lal, it is found that plaintiff Jageshwar Lal is in occupation of only 192 square meter and remaining 74 square meter in the said survey number 47 is under occupation of defendant Sri Peter Balla, but the subject area is lying vacant. But kindly consider this, how the local investigation commissioner have come to a conclusion that I am occupying it. When ex facie report marked as 3G indicates that the land is lying vacant. Lord, the report, Lord knows the legal impact of a report submitted under Order 39, Rule 7 and Order 26, Rule 9. The moment report under Order 26, Rule 9 is prepared, it becomes part of the trial, which is subject to be accepted by a court.
So dispute A will end. You say that I am not in possession, occupation of that portion of land, and if any lawful owner thereof take repossession, I shall not prevent.
But,
You that I am just recording and passing the order.
yes, Lord.
Huh?
Yes, Lord. Yes, Lord.
Look at it.
I'm no problem. Yes,
Huh? He is
Yes.
saying I am not in occupation.
Yes.
I am not occupying that land, and if full owner occupied that land, I shall not prevent.
Yes.
Don't understand, Your Lordship.
Huh?
No, I'm in
I don't
difficult
know.
situation because I don't know the exact position of the land. It is on record what it is there. It says as per the commissioner's report, it says that he is in occupation. And now he is
But
in-
now report says that the said land is vacant.
Line, that doesn't mean,
74 square meter.
that doesn't mean that he is not in occupation.
Maybe constructive possession or anything like that. But if he
This
says,
is not the only area. Kindly see complete.
yes, yes, yes.
On demarcation of the land bearing survey number 49, there are 3 survey numbers. It
Hmm.
is found that defendant Shiv Peter Bala is in occupation of 138 square meters in survey number this, and 207 square meter in survey number this, and 74 in survey number this. Whereas the recorded area is only 1345 square meters. So he's in occupation of,
But the suit land is survey number 47. Let's confine with 47 only. No, let's confine with 47. I'm the adjacent plot holder. I'm having my property recorded. It's a claim of the
47.
plaintiff that being an adjacent plotter, I have occupied the part of suit land. Their land. Because not can you see the schedule of the plaint? It only dates to survey number 47. Not can it turns to page 4 of the
point is that if he says that he's not in occupation of 74 square meters,
Hmm.
if suppose now he.
And he will not prevent if the lawful owner of that portion take possession and enjoy the same.
Yes.
And he will not prevent anyone.
Your Lordship, may I come tomorrow, Your Lordship? I will consult with my client and it can be disposed of.
Yes.
Yes,
I shall record this and I shall dismiss this. The entire dispute is
It's finished.
Ah.
I just consult with.
Ah.
Come to.
Yes. Whether Supreme Court has says or such and such, that every problem will be solved.
Yes.
So come tomorrow. Yeah. So I am keeping on the top.
Yes, on the top.
Especially
Yes,
paper.
especially
Okay.
if it's-
Okay.
Just a minute. Yeah, I'm here, sir. Yes, Your Lordship, I am for the appellant. I have filed the paper book, given the copy also to the other side.
Who is your other side?
Mr. Rakesh Palguru.
So not today or anything. What can be done? Next circuit. Or
Next, I can't do
within
anything. Your
2
Lordship.
days, within 2 days it would be possible.
It is not possible, Your Lordship. Next circuit. The second appeals, all 3 second appeals has to go to the next circuit, Your Lordship, because I don't think that sufficient, and nobody is there also for the other side. And sufficient,
Acha, yes.
sufficient time.
Miss Nark, London Senior Counsel submits that the paper book has already been submitted and a copy of hereof has been served upon the learned advocate entering appearance on behalf of the respondent. ঠিক আছে? আচ্ছা। Today none appear. Today the respondent are unrepresented. The respondent are unrepresented. ঠিক আছে? হ্যাঁ? 19 would be respondents.
Next one,
Other
paper book.
but 20 would be respondent. One unrepresented in view thereof list the matter before the left circuit bench, subject to his convenience. Here would be respondent, only one.
Same position, Your Lordship, item number 20, paper book filed, copy has been given, other side is not
Paper
appeared.
book has same order. 21,
Same position.
21, but there are 2 applications.
In all these 3 appeals, Your Lordship, it may be recorded and none appears for the respondent too.
And none appears for the respondent, yes.
Yes.
21 also, 21,
21 also same position.
same. Paper book has been filed.
Yes, paper book has been
Oh,
filed.
okay.
Copy has also been given.
Yeah.
22, CPM 25 of 2024.
22.
I'm there for the opposite party.
22 is a contempt application.
No, content disposed of. Can be listed today. Contempt for perjury, they are seeking an action against my client for perjury. They say that some wrong affidavit has been found in contempt. Contempt disposed of. And see that affidavit contempt disposed of. Now they want to invite this court to seek a proceeding of perjury.
Are you appealing?
I'm for the petitioner. There's a direction for filing
I'll
affidavit.
take time, so I'll use my red lights.
As a last chance, time may be extended.
Oh. Acha, Mr. Joypal Lalit advocate appearing for the
Can application and the opposite party responding.
can order topic can under Lalit advocate appearing for the appearing for the C. Thomas Varghese.
Yes.
Acha, appearing for the opposite party in can 1 of 2024 pays for extension of time to file affidavit in opposition. Yes, stop. Pair is considered and allowed. Let such affidavit in opposition to the application being can 1 of 2024 be filed within 2 weeks from date.
As a last chance.
With a copy to Mr. Prasant. As a learned advocate appearing for the applicant.
As a last chance, my lord.
So I am to observe that they have taken time.
Kindly see the record.
No,
Oh.
I'm not filing opposition, let the matter be taken up. Let it be taken, let my brother press, I have no problem, I'm ready with that. I can always, in a High Court, I can without opposition, I can. Let it, the matter be taken up, let it press the application, I'm ready with that.
Okay, give
It is
2
so
weeks
serious
time.
that-
See.
No, already twice direction was given. He has not filed the affidavit.
That's fine,
Now he is,
Okay.
the last chance may be given.
I'm ready with
I
that.
also cartoon. Pair is considered allowed to cartoon. Pair is considered allowed. তারপর থেকে কেটে দিন আচ্ছা কেটে দিন মিস্টার প্রশান্ত আচ্ছা মিস্টার প্রশান্ত হ্যাঁ কেটে দেবেন তো তারপর থেকে তো বললাম মিস্টার প্রশান্ত লালিত অ্যাডভোকেট representing the applicant oppose such pair stop contending that the several adjournment has been taken on behalf of the opposite party on behalf of the opposite party ঠিক আছে to file affidavit in opposition stop আচ্ছা আবার having heard the আচ্ছা advocate I having heard the learned advocate defending the respective parties, I heard that such affidavit is required to be brought on record for effective adjudication of this. Is required to be brought on record for affidavit for the effective adjudication of the application. Stop. Accordingly, as a last chance.
I'm
Satisfied?
happy.
Happy. As a last chance. Time to file affidavit in opposition to the application is extended for a further period of 2 weeks. Reply, if any, be
Within
filed
3 days.
within 3 days. Acha. Let the matter appear before the appear after expiry of the period specified.
Let the matter.
Specified towards exchange of affidavit. ঠিক আছে before the next available circuit bench, subject to his content.
Item number 21, I am appearing for the respondents. So my.
Here in this matter you will take
No.
time for.
I am the respondent.
Ah.
Actually, the matter was adjourned to next circuit. So my appearance may be recorded, my lord, in the second appeal.
Oh.
Babul Roy.
Yeah, so 21 and non appears, but you inform this matter to
Mrs. Nag, I will inform.
21 ওনার নামটা দিয়ে দিন, অ্যাপিয়ারেন্সটা দিয়ে দিন।
Are the respondents?
21 আলাদা order করবেন, হ্যাঁ। 21 you will read that Mr. Posan did not raise any objection. হ্যাঁ? হ্যাঁ। 21 ওখানে কি দিলাম? You want also time today?
No, I am ready.
Oh.
She prayed for time. I am not having any objection.
She submits that a paper book has been prepared and submitted in the department and copy of the same has been served upon
Yes, I
the
received.
respondent.
I received.
But respondent was not present there.
I
And
was
hence
up
he
to
said,
number 1, my lord.
and he said, so let it within 2 days, it would be not possible.
It is not
Place it,
difficult for lordship also because time is not there.
place is before next circuit. আচ্ছা, so ये कौन है? আচ্ছা, Mrs. Nath, learned advocate representing the petitioner submits that senior advocate representing the appellant submits that the paper. Oh, road every day you are writing. This thing submits that a paper book has been prepared, comma, and a copy of the
उसको ये काम करने के
copy whereof has been served to the learned advocate
Understand.
representing the respondent. ঠিক আছে? আচ্ছা, yes, stop it. Here Mr. Posan's name would be given. Mr. Posan. ওপরে, হ্যাঁ। আচ্ছা, ঠিক আছে। She prays for, he submits that this matter be placed. She submits that this matter be placed before the next circuit bench. Mr. Posan did not oppose such submission. ঠিক আছে? In view thereof, place the matter before the next circuit bench. Comma, subject to his convenience.
I am deeply obliged.
Yes.
Item 23, CR 59 of 2024.
Pass over how many?
Lordship, I'm for the respondent, Lordship.
Not today, do it tomorrow. If possible, if you want to do.
So it will take time. Lordship, 227 have been rejected by the trial court that has been challenged under Prevention of Corruption Act. Some time it will take.
Next circuit.
Then Lordship, because their application, they have.
Okay, not today.
Item 24, WPA 97 of 2022, with WPA 51 of 22.
My senior officer yesterday got. But when I identified 24 to 25.
You have some difficulty. Next circuit. Okay, next circuit. Huh? Yes. Or to proceed. As paid for, Calcutta order করে দেবেন. As paid for on behalf of the petitioner. ঠিক আছে? As paid for on behalf of the petitioner, let be the next circuit bench, comma, subject to his convenience. Yes.
Item 27, CRA 1 of 2023.
27.
Item 27, CRA 1 of 2023, with plan 1 of 2023.
And for the state, connection of NI.
None appears.
Lord, he is not in station, Lord, with the 27. He is not in station, Lord, let it be in next circuit.
An
Counsel
adjournment,
for the appellant is not there.
an adjournment has been sought for on behalf of the appellant, though Mr. Kormokar. 27. Sought for on behalf of the appellant, though Mr. Kormokar, learned advocate representing the state respondent, is present. ঠিক আছে? আচ্ছা, stopped in view thereof, list the matter before the next circuit bench, comma, subject to his convenience. Yes.
Item 28, CR 16 of 2023. My lord, I am for the petitioner hearing, let the matter be posted on the next one.
My senior is appearing for the respondent.
He's standing behind you.
I for the state, Lord.
Huh?
Next one.
Okay, next circuit as paid for on behalf of the petitioner. As paid for on behalf of the petitioner. হ্যাঁ কালকে যে yes 29
Lord, I am for the Port Blair Municipal Council 2 and 3.
I am for respondent number 1, my lord.
কোনটা তাই না হ্যাঁ
My lord has fixed it whether Lord, I have filed my affidavit in opposition. They have to file reply.
item 29
Yes, my lord.
yes yes
PBMC is the contesting party.
হ্যাঁ
PBMC is the contesting party. In this
So
matter.
let it be recorded that the administration will not be in the opposition. नहीं लिखा है ना, तो फिर I can use my reply address in the Portal Municipal Council opposition.
whether you file opposition or not.
But the order passed by the municipal council regarding the demolition has been challenged by the applicant, petitioner hearing.
Prayer.
Who is for municipal council?
I am
You
appealing,
or-
I am appealing.
Oh, your order has been challenged.
Yes, my lord. I have filed my affidavit in opposition also, my lord.
আচ্ছা
In both the matters, my lord.
Secretary Municipal Council.
আচ্ছা ইয়ে ভালো এই
Three.
Mr. In course of hearing, in course of hearing, I have been informed that the municipal
Respondent number 3, my lord.
respondent number 3.
My
2 and 3, my lord.
So that affidavit in opposition to the writ petition has already been filed on behalf of the respondent number 2 and 3. Stop. And copy of thereof have already been served upon the petitioner. Stop. Mr. Joypal, learned advocate, repenting the petitioner, prays for extension of time.
Yes, yes.
Prays for extension of time to file affidavit in reply. Let such affidavit in reply be filed within 2 weeks. List the matter for further consideration. After 2 weeks, in the next available circuit bench, subject to his convenience.
Model make any base.
Okay, there is interim order.
No, no, my lord, it has already been expired, my lord. Expired only. Check. Expired.
When it was expired?
Long back, I think, my lord. It was expired.
In course, then it was made operative.
My lord, so far as I have in, my lord, knowledge, it has been long back, it has been expired.
When it was reimposed, Mr. Joypal.
Because I've been doing matters since inception, you know. Isn't it?
Okay, Mr. Joypal, learned advocate, appearing for the substance, record says that on February 20th, 2024, the interim order was directed to continue till 31st March 2024.
Thereafter also, then I can show you. I'm not obtained the copy, I can show you.
Okay, February,
I can
March.
show it.
Oh.
There is.
তারপরে কিন্তু March 21, April, that means April, in April.
May I see the record, ma'am?
Why not?
May I? Just I'll assist the court.
Yes. Since it was extended up to March, you have to find out from April. Oh.
You got to make an application for reimposition, not to see 12 December 2024 order.
Well, ultimately, it has not been imposed or reinstated.
No.
And you have not filed also application. So what can be done? No change of circumstances. Mr. Joypal, learned advocate, Mr. Joypal, prays for reinstatement of interim order passed on Acha, passed on whether February 6, 2024. Justice Hiranmay Bhattacharya.
Yes.
Huh? Acha, on, you will check, date, on 6 February 2024. Stop. Acha. What are they? You are not seriously opposing this? Acha.
Because this commission.
Acha, learned advocate appearing for the respondent oppose such pair. Stop. Acha, however, oppose such pair. Stop. Having heard the learned advocate and upon perusal of the record, ঠিক আছে, I find that there is no change of circumstances in the meantime. ঠিক আছে. In view thereof, the interim order passed on such and such is reinstated. And it is directed, it is reinstated and stop. Let such interim order be continued till the disposal of the.
Then, my lord, they will already sought several times for filing reply, my lord. My lord.
They will not file reply at all.
They are-
Till the end of March,
Yes, yes.
till the end of March of 2025 or until further order, whichever is earlier.
Okay.
Yes. Yeah, Mr. Olo, haphazardly, you will arrange, or I will give it pen name.
Make all the conformity.
Oh, 29, now 30 is also same.
Same.
Oh, connected, okay. So you appear for municipal corporation. So there are some passover matter. Let it be called, called passover matter 226.
WPA 55/25.
What's your instruction in this matter?
Picture is that they are using staircase. Please use of the offers of public as well as the tenant those who are using first. Now, my lord, the orders passed by this honorable court, the matter went to honorable division bench. The division bench has said that they want that the premises which they are using, that has to be allotted in their favor, but that court has turned off and made ultimately to them to file a representation for allotment of a shop. That application has to be considered. There are the 3 subsequent orders, not repetition. This honorable court has directed the PPMC to consider the representation. Based on that, we have considered, we passed an order.
Within 2 days.
Not
First, thereafter that apart, it is appearing you have granted a license in favor of one A Murthy or anything, something.
Yes.
So why this discrimination? It has been.
At the present stage, I pray that I will be permitted to file my affidavits.
Yes.
My lord has directed me to take instruction. I have taken instruction. This is the facts, my lord, because the staircase was occupied by the petitioners. But this court has already said that the staircase which is occupied by them, that cannot be allotted in their favor.
So you file affidavit, in the meantime, in exchange affidavit,
Yes,
interim order will be extended.
but continue, but a particular period. not-
Yes, particular period. Acha.
It's up to you.
লিখুন আচ্ছা আচ্ছা লার্নেট অ্যাডভোকেট your good name please
Rakesh,
আচ্ছা আচ্ছা Mr. Rakesh Kumar learned advocate আচ্ছা has entered appearance on behalf of the respondents আচ্ছা he prays for leave to file affidavit in opposition to the writ petition stop আচ্ছা pair is considered and allowed. Let such affidavit in opposition be filed within 2 weeks. Reply, if any, be filed within 2 weeks. Acha. List the matter before the next available circuit bench, subject to his convenience after expiry of the period specified toward exchange of the affidavits. ঠিক আছে? Specify towards exchange of affidavits. ঠিক আছে? Stop. আচ্ছা, interim order passed on 31st January 2024 is extended till the end of March 2025 or until further order, whichever is earlier.
Since he is appearing on behalf of the PBMC, respondent number one, I will be appearing on behalf of respondent number one.
Your name here.
His chief secretary was,
Do you want to file affidavit in opposition?
Because.
but the order was passed by PBMC. Against that order, they have come. Because, my lord, the writ has to be filed being the head of the institution. So, chief secretary being the head of the institution. So, they made the chief secretary is also a party to be as informal in nature.
He is
But-
respondent two only.
So, the chief secretary was represented.
Sorry.
The chief secretary was.
Rakesh Kumar, the learned advocate appearing for the respondent number 2.
Yes, ma'am.
He pressed for leave to file, ঠিক আছে? And Miss Das's appearance record
For respondent number one.
One.
for respondent number 1. Same order,
Yes, yes, sir.
226.
Oh, Blair.
Yes.
Appearance may be recorded,
In all matters, your appearance will be.
Okay.
Item 7, WPA 11 of 2025.
And for the official respondents, my lord.
I have already dispatched the copy of the petition to the added response. But that was on Monday, but by the time, because it's not even the 1,000 number. I've dispatched them most of.
আচ্ছা
The private respondent was not
আচ্ছা
added.
Miss Mini learned advocate repenting the Miss Mini learned advocate repenting the petitioner submit that the service upon the added respondent as yet to be completed. ঠিক আছে? হ্যাঁ আচ্ছা আচ্ছা He prays that this matter may be adjourned to 10th stop. As pair is considered and allowed, let the matter appear on 10th for further consideration.
My appearance may be recorded, my lord.
Huh?
I appear on behalf of the official respondents. Respondent number
Okay, huh?
1 and 2, my lord.
Yes.
Item 8, WPA 3 2024.
Huh?
Item 8, WPA 3 2024.
8 none appears. What can be done? Yeah. Next circuit, huh? Okay, not today. Let them come if there any urgency. Not today. 9, 10.
Item 12.
Oh, I think 12.
My lord, I am appearing for the petition, my lord.
Hmm.
My lord, here, the case was initiated against this petitioner, my lord. My lord, under section,
227.
my lord, this is my application, my lord, the
Which case? POXO,
also.
9 PM and 10.
Then, my lord, the allegation, my lord, may kindly see at para 4.
To pass forward, not today. Not today.
Item 14.5 of
I'm for the petition, my lord.
Huh?
I am for the petitioner.
Yes, you are, in this
It's-
matter, you are for the petitioner, who is the other side, or it has not been admitted.
Dinu was appearing before the trial court, my lord. I have served the copy to her since she is appearing before the trial court.
Before admission. That's
My-
okay.
Yes, before admission only I have, because my
What you have
application.
challenged in this
I
matter?
haven't challenged anything, my application, my lord, under order 26 rule 9 is pending since 2021.
Hmm.
If your lordship can come to page 12, para 10, my lord. I am the judgment debtor, my lord, and Ms. Dinu, she was appearing for the decree holder. So, my lord, judgment debtor, his share has already been decided by Honorable High Court.
It is a partition suit.
It is a partition suit.
Preliminary degree was passed.
Yes, my lord.
Thereafter, commissioner was appointed.
Commissioner was appointed, yes.
Appointed. Commissioner
Submitted the report.
Commissioner
submitted a
the
report. That was accepted. Or
That was objected by some intervening parties, that they're saying that separate civil suits are pending, where I am not the party to the suit. Unnecessarily, my share, which I am admitting that I will leave, I have already left other shares. As per the Honorable High Court, whatever my share, my lord, and even in the demarcation also, my share was located, my lord.
Allocated to
It's
each of.
3/4 share of the decree holder, my lord. In terms of the order passed by Honorable High Court, I am possessing only that share. But since because of the pendency, due to the pendency of this execution case, my lord, that my records have not been corrected, because
no,
since I
final
am-
degree has been passed.
Yes, my lord. Final
Eh?
decree has been passed. No. Final decree has
So
not been.
what the execution case, 1 of 2012?
Yes,
It was
in
filed by me.
execution case, my lord, other
was filed
parties
by
have.
me.
I went
intervened.
to get executed which degree or order?
Preliminary decree was passed,
Yes.
the report was called,
Ah.
commissioner submitted a report.
Ah.
Before it could be finalized, one unknown person appeared before the court as saying that.
They are the
this thing is
encroachers.
Pending, they are the encroachers of this particular land, saying that our title is at stake.
Civil suit is pending, so
Therefore,
execution case
should
has to
not
be stayed.
proceed. Execution should not proceed. So it is.
Execution.
Yes, my lord.
Execution should
In
not.
execution case, they have appealed, because I am the judgment debtor.
Execution is
She is for the
still
decree
not
holder.
clear to me. That means the partition suit is yet going on. Unless it is the final degree is passed, partition suit is not disposed of. So why the execution case? In connection with which case? 1 of 2012.
Yes, one of them.
Why execution case?
Probably filed because both of us were not there in the trial court. But at the end stage, both of us came. Execution was pending, so we started proceeding in that.
I received a notice and I was made as judgment debtor. I appeared before the court and I filed order 26 rule 9 saying that I am ready with the whatever my share. I am ready
Okay,
to.
I have understood so far
Release
from the
of shares.
submission made on
Because-
behalf of made by both of you.
My lord.
What I have understood is that preliminary degree was passed. Commissioner was appointed.
Commissioner
He
was
is
appointed in execution case. They have filed execution case, Your Honor. My lord.
Oh, to
Partition-
get the
yes.
preliminary degree execution.
Yes, they have filed execution execution case without proceeding with the partition suit. They should have filed this partition appointment of partition commissioner in the partition suit itself, but they have filed a title execution case. In that, I was made a judgment debtor. Before that, my lord, challenged
You
I
are
am the
one of the
judgment
questioner.
yes. And I have challenged that decree, my lord, before the Honorable High Court. Honorable High Court has dismissed my application saying that you are entitled for 1/4 share, which as per, so I was ready with that. Okay, I'll release other shares, other whatever this property land is in my possession. I have already released all those shares. I am only entitled. I have accepted
I am
that.
also not standing on her way.
I have accepted that. I am ready with my 1/4 share. And
even before the execution case, after I received the notice, being a judgment debtor, I received a notice and Order 26 Rule 9, I filed, my lord. I filed an application that I am ready with my share, like as per the Honorable High Court, since my application was rejected, second appeal was rejected.
Generally, when partition suit preliminary degree is passed, then preliminary degree is nothing but declaration of share.
My lord, but they have filed execution.
One
case
liberty or opportunity is given to the parties, to the co-sharer, that you set a partition amicably.
My lord.
On being failed, they again come that we have failed
We have failed.
to get the property partition amicably. So appoint partition commissioner. Commissioner.
Yes, ma'am.
Hmm. Then in the given case, in this case, partition commissioner was appointed.
Appointed in execution case, my lord. After the partition preliminary decree was passed in a partition suit, my lord, the case was disposed of. They filed a title execution case. In that, I received a notice.
Case was disposed of means final degree was passed.
No, preliminary decree was passed, I think.
Otherwise, partition suit will not be disposed of.
That was challenged before.
Partition suit is disposed of only when final degree is passed.
Yes. Final degree was passed.
The
That
suit
was
is
challenged.
passed in preliminary form.
It was initially not a partition suit. What has happened? The judgment debtor
Okay, you take instruction, you read, then you come.
will come tomorrow.
Huh? Tomorrow, now what tomorrow?
Yes, let us come tomorrow. Because very innocuous prayer.
Innocuous prayer, my lord, my
We
Order
come to
26
court,
Rule 9 is
like-
pending since 2022, my lord.
Let
Partition commissioner has already filed a report. Then what for it is kept pending? So I have come
some
before
third party
this.
has intervened.
Yes, that is.
Some third
They are
party.
not the party to the suit.
They are not party to the suit.
So who-
And I am not a party to their suit.
Have
So
you?
why I will be hampered, my lord?
Have you made them party in this proceeding?
Why I'll make, my lord? Because I was not made to the party to the suit. What they are saying that one civil suit is pending, which I don't have any knowledge.
What I propose, subject to your acceptance of your lordship, I will place tomorrow the Honorable High Court's order by which the execution was filed, because it up to.
Okay, tomorrow, come tomorrow. Get ready and
Mine.
come tomorrow. Okay. That's all.